హలో స్టూడెంట్స్, వెల్కమ్ టు తిరుమల క్లాసెస్. ఈ వీడియోలో మనం రైట్ టు ఇన్ఫర్మేషన్ యాక్ట్ గురించి మాట్లాడుకుందాం. ఫ్రమ్ పాస్ట్ ఫ్యూ ఇయర్స్ రైట్ టు ఇన్ఫర్మేషన్ యాక్ట్ ఈస్ దేర్ ఇన్ ద న్యూస్. Sir, why it is in news? How it is important to your examination? This is not only important for UPSC civil services but also state exams and other exams at both central and state level. When I say right to information act, this was made in the year of 2005 under RTI Act. Right to Know Information Act 2005 it was created. But what is the background story of it? Remember, it was created 2005, but right now we are in 2025, which means this act completed successfully 20 years. When it is completing 20 years, there is a comment on this. This Right to Information Act is meant for promoting accountability, transparency, and people participation in the administrative system. What do you mean by accountability? The government should be accountable to the people. Transparency means what is happening in the government, that should be very much transparent. Why, sir? All the administrative activities, all the activities of the government of India is based on taxpayers' money. When I say taxpayers' money, it is people's money. That is why whatever government is doing, that should be transparent. Whatever the government is doing, government is always accountable to the people of India because this administration is based on people's money. Hence, the Right to Information Act is always meant for building or ensuring accountability and transparency in a way that is going to controlling political corruption or public corruption. That is why India brought this act in the year of 2005. But by 2025, it's been 20 years, but there is a comment on this. For example, there were several amendments to the Right to Information Act. One of that amendment was happened in the year of 2019. Recently, one more bill was created. One more act was created, that is something called DPDP, Digital Personal Data Protection Act 2023 also created. Because of 2019 Right to Information Act amendment, because of Digital Personal Data Protection Act 2023, there were some changes happened to Right to Information Act. Hence, it is declining its transparency and accountability. That is one criticism on Right to Know Information Act, which is ongoing. One more criticism is, Act was created to build transparency and accountability, but there is no staff. Always, in the Right to Know Information Act, there is a scarcity of staff, obviously, information getting delayed. Another problem in India, record keeping is the biggest problem. When records are not keeping properly, how Right to Information can provide information to the people based on their queries? Likewise, after 20 years, we are going to detail scrutinizing this Right to Information Act, but expert says it is very much important for democratic system like India, but problem is it's a transparency, accountability. I mean to say the core objectives of this Right to Information Act is going to decline. Hence, there is a need for reforms under Right to Information Act to overcome existing challenges. But what is the background of this? In the year of 1948, there was something called as Universal Declaration of Human Rights. I mean to say after World War II and World War I, the world given much importance to human rights. Under United Nations organizations, in the year of 1948, there was a declaration called Universal Declaration of Human Rights. This declaration must be accepted by all the member countries, including India. Based on this, India also accepted human rights. We created human rights commissions and many more provisions to protect human rights in India based on Universal Declaration of Human Rights in the year of 1948. In order to strengthen human rights in more better way, to create confidence among the public, transparency, to ensure public participation, I can say participatory democracy. See, India more or less like representative form of democracy, but that should be changed into participatory democracy. What is participatory democracy? People should participate in the administrative system of the nation. Hence, we call it as participatory democracy. To ensure participatory democracy, we made local self-governments, that is panchayat and municipalities. So participatory democracy is more important than representative form of democracy. To ensure this participatory democracy, transparency and accountability, in the year of 2002, the Government of India enacted Freedom of Information Act. In the year of 2002, the Government of India initiated Freedom of Information Act 2002. But this Freedom of Information Act 2002 replaced by Right to Information Act in the year of 2005. అంటే earlier దాని పేరేం పేరు ఫ్రీడమ్ ఆఫ్ ఇన్ఫర్మేషన్ యాక్ట్, దాని తర్వాత ఏమని పేరు మార్చాం రైట్ టు ఇన్ఫర్మేషన్ యాక్ట్ 2005 చేసి దిస్ ఫ్రీడమ్ ఆఫ్ ఇన్ఫర్మేషన్ యాక్ట్ ని రీప్లేస్ చేయడం జరిగింది. బట్ రిమెంబర్, అండర్ దిస్ రైట్ టు ఇన్ఫర్మేషన్ యాక్ట్ 2005 empowers every citizen to seek information from public authorities. If you are a citizen of India, you have a right to get information from public authorities, except few exceptions that are mentioned under Section 8 of RTI Act. Section 8 of RTI Act is dealing about what are the exemptions. For example, personal data can't be requested. The data which is matter of internal security cannot be discussed or cannot be disclosed. The matters which are important for sovereignty, which are affecting national and international issues, cannot be disclosed. Which means under Right to Information Act, Section 8 is giving some exemptions, which means that exempted information cannot be requested by any individual in India. Even though they requested, the government denied those information under exceptional category, Section 8 of RTI Act. But why? What is the fees of this? In order to file an RTI, it is just a cost nominal fee of 10 rupees only. Why it is meant for? Transparency, accountability and participatory democracy. As I told earlier, this is known as Freedom of Information Act. It is replaced with what? Right to Know Information Act 2005. But even after 2005, there were many incidents. At present, I would say, we have a concept called as fundamental rights. We have a concept called fundamental rights. In this fundamental rights, Article 12 to Article 35, they're important. Within this, there is something called Article 19, right to freedom. Under this Article 19, at present, there are 6 sub-fundamental rights. Under this one, I can call them as like right to freedom. Article 19 is right to freedom. Within this Article 19, there is something called right to information. At present, right to information is a fundamental right under Article 19 of Indian Constitution, important for prelims. I mean to say, we will include something to fundamental rights every time, but who will do them? Remember, under a case called Raj Narayan versus UP government. In this Raj Narayan versus UP government, the Supreme Court of India established right to information as a fundamental right under Article 19. So at present, right to information is a fundamental right under Article 19. But I told there are challenges to this. Privacy is a one challenge. Digital Personal Data Protection Act, these are having certain limitations on this right to information at present. Hence, we need to know what are the challenges. You must know what is the significance and challenges for this right to information act. Significance means we can add advantages. Challenges means what are the problems that are facing right now. And then we need to write for way forward for this right to information act, followed by conclusion. When you do this, it is important for both prelims and mains. But I tell you what are the features that are present under right to information act. There is something called institutional setup. What do you mean by institutional setup? Under this act, we have created CIC, SIC, Central Information Commission, State Information Commission. These were created under this act, hence we call them as statutory bodies. These institutional setup was created under Right to Know Information Act 2005. They also created SPIO, CPIO, Central Public Information Officer, State Public Information Officer. Under this act, right to request information from public authorities, that authority will disclose information within specified time. But I said Section 8 of RTI Act is meant for exceptions. Some of the exceptions, information cannot be provided, like affecting sovereignty, internal security, affecting bilateral ties with other countries, personal information, like that they have created. So hence, this Right to Know Information Act is important for both prelims and as well as mains. Just go for what are the provisions, significance, challenges, and way forward. In fact, we covered them in our current affair classes, but still, it is very, very important for upcoming mains and as well as prelims. Already there was a mains question UPSC and Group 1 based on this particular topic. Again, there is a high chance of reappearing the same question with a little modifications done by examiner. Thank you. Have a nice day.